As always, the opinions expressed in this program do not necessarily reflect the official policy or position of DKI APCSS, the U.S. Department of Defense, or the U.S. government.
The most affected by climate change, they beg, they hope to get the new law protecting them. So you can also see that United Nations is stepping back, not doing enough. So those countries decided to act on the regional level to form regional law.
Aloha, and welcome to Dialogue, where conversations shape security. I'm your host, James Minnich, Colonel United States Army retired and professor here at the Daniel K. Inouye Asia Pacific Center for Security Studies in Honolulu, Hawaii. It's a pleasure to have you with us for Dialogue 28, Law in Rising Seas. We're navigating some choppy waters today, exploring a challenge that quite literally could swallow entire nations whole. The Pacific Island nations are on the front lines of one of the most urgent and complex challenges facing the world today: rising sea levels caused by climate change. These small island states spread across the vast Pacific Ocean face an existential threat that goes beyond environmental concerns. It touches on sovereignty, territorial integrity, and human security. Imagine entire communities forced to abandon their ancestral homes, their cultures, and the islands they've inhabited for generations. As sea levels rise, low-lying islands like those in Oceania, such as Kiribati, Tuvalu, and the Marshall Islands, are all at risk of losing significant portions of their land, or in most extreme cases, their entire territories. These nations face a critical challenge with this loss of land, as territory is a foundational component of statehood. According to international law, a state is defined by three key elements: a permanent population, a defined territory, and a government. If rising seas erase that territory, what happens to the state? This isn't just a hypothetical problem. Predictions suggest that some Pacific nations could lose most of their land by the end of this century, rendering them uninhabitable and creating large numbers of displaced people, often referred to as climate refugees. However, international law does not currently recognize this status, leaving these populations in legal limbo. Beyond the loss of land, rising sea levels also affect a nation's maritime zones. According to the United Nations Convention on the Law of the Sea, or UNCLOS, countries are entitled to exclusive economic zones extending 200 nautical miles from their coastlines. For Pacific Island nations, this is a crucial issue because their maritime zones are often disproportionately large compared to their small land masses. In fact, many Pacific nations rely heavily on their ocean resources for this economic livelihood. Any reduction in their EEZs could devastate their economies and limit their sovereignty over their natural resources. At its core, this issue is about more than legal rights and maritime boundaries. It's about human security and cultural survival. The Pacific Ocean is not just a geographic feature for these island nations. It is central to their way of life, their identity, and their cultural heritage. Therefore, the legal measures being taken by these nations are about preserving their future, not just in legal or economic terms, but in human terms. By safeguarding their territories and maritime rights, they are protecting their cultural identities and ensuring that the future generations can continue to live in and with the Pacific. Joining me today is Dr. Joanna Siekiera, an international lawyer specializing in legal warfare and a contributing author to this center's 30th anniversary book, The Indo-Pacific Mosaic. I have the privilege of being the editor of this volume, and Dr. Siekiera provides a unique legal perspective on this growing security challenge, drawing from her chapter, Law in Rising Seas, Navigating Ocean Change. Joanna, thank you for joining us today, and it is indeed a pleasure to welcome you to our program.
Aloha, James. Thank you very much, and good evening from Poland.
Yes, and it is early morning here, but in different times around the region, without a doubt. By convention, I like to invite my guests to share their stories. And so, Joanna, as you share yours, I hope that you'd include in there your voyage, your Pacific voyage you took last year, and share how that kind of helped shape some of your thinking.
Thank you, certainly. Ladies and gentlemen, I am an international lawyer, also legal advisor here at the War Studies University in Warsaw, but I am also a legal consultant to NATO and Marine Corps University in Quantico. My passion is Indo-Pacific, wondering why, what Poland has to do with Indo-Pacific. The thing is, when I was picking up my topic for a bachelor thesis, master's and doctorate, I was wondering, what can I do to make a change? Most people in Europe, of course, they'll deal with European Union. But here I would like to quote your former US Secretary of State, John Hay, in the late 19th century. And he said, Mediterranean was the ocean of yesterday, the Atlantic is the ocean of today, and the Pacific is the ocean of tomorrow. But this tomorrow is already happening now, and your center is doing an enormous job in promoting peace and stability in the region. So I did my doctoral studies in New Zealand at the Wellington Victoria University, and then my postdoctoral research studies in Bergen in Norway. And the last position I took exactly gave me this unique opportunity to sail across the Pacific Ocean. I was sailing 2 months the open sea without entering any harbors. From Palau up to, from Fiji up to Palau, and then I had privilege to also fly via Guam to Honolulu, and I visited your center actually 2 times, which I keep in my heart, this beautiful visit. And this voyage proved me that what is happening from the ocean change, but also military threats, because I've seen Chinese vessels. We will talk about that, but 2 months open seas, only Chinese vessels on the way, no other. So we must also remember the legal connotation of the threats, and I'm here to explore that niche because I believe that, yes, there are experts in security and economy, but still we are missing international law in this whole mosaic. And also I'm very grateful to be in your book because this is just magnificent piece, and I'm happy to contribute.
Well, thank you for that, Siekiera. Let's go ahead and open this dialogue and talk about the legal frontier of climate change. And I kind of spoke in the intro, but as ocean levels are rising, Pacific Island nations are in fact adopting innovative legal measures to protect their territorial integrity and sovereignty. And so maybe you could start us off and help explain, how can international law evolve to better support states vulnerable to climate change? And then what lessons can other regions learn from Oceania's approach?
Yes, thank you, Professor. This is perfect question because people usually don't see this direct connotation between climate change and losing sovereignty. But exactly as you mentioned at the beginning, according to Montevideo Convention 1933, there are 3 elements for an entity to be called a state, and one of them is indeed territory. But this territory might be gone not because of the war, annexation, invasion, but indeed climate change. United Nations Convention on the Law of the Sea is very clear how to calculate, to demark, delimit zones. So from the land base on the land, we calculate 200 nautical miles. But what if that land is sinking? What is not anymore in the position? It's like below the sea. So from where we calculate those 200 nautical miles? And it's very important for the island states because their vast majority of territory is indeed maritime territory. So it's economy, it's access to pipelines, to cables, exploration of the seabed, for pharmacy, for security, for technology. But they might lose that because they will no longer be legitimate under international law to possess this land. So we are risking instability. And according to Article 1 of United Nations Convention, the aim of UN, all of us, is to keep the status quo, to keep peace and stability. So this ocean change is affecting the stability in the region, primarily in the Pacific, but also we look at Southeast Asia, at deltaic countries like India and Bangladesh. And when those countries are vulnerable, somebody will make use of that. And that somebody is definitely Chinese People's Republic, because they are perfect in using those vulnerabilities. And unfortunately, but ocean change is helping them. So this is a big, big topic to explore.
Oh, that's fascinating. And you know, those that live in the region, they have a appreciate that these small islands, there could be hundreds of them in a nation, and they're spread across. And if nations start to, if islands start to be submerged or go underwater, and you looked at, well, that part of our EEZ is diminished because that far-reaching island isn't there anymore. It starts to shrink the total area that they have. And so maybe we can pull a little more on this mapping of the future, as it were. I mean, I noted, and you have said, that Oceania, I mean, these states are proactively defining their maritime boundaries by depositing maps within the United Nations. And some of this has been going on for a few years now, but they're setting precedents in international law in doing so. And so I want you to talk a little bit about what are the implications of these actions for global maritime law and in fact, the future of territorial disputes.
Definitely. And here I see the emergence of the new regional custom. In international law, the most well-known source of law is treaty, agreement, arrangement, convention, and so on, despite the name. But equally legally valid source of law is custom. So it doesn't have to be written down, but as long as all the parties involved, they agree that what they do or don't do has some legal effects, then we can conclude that such action brings rights and duties at the international level. So what those countries are doing, and there are 13 of them. I have a list, I checked. Unfortunately, the list is not growing, which is also giving us a sign, but I will read from the latest Commission on the Limits of the Continental Shelf in the Division of Ocean Affairs and the Law of the Sea. Cook Islands, Fiji, Federated States of Micronesia, Papua New Guinea, Solomon Islands, Palau, Tonga, Tuvalu, Tokelau, Kiribati, and of course, Australia, New Zealand, and France on behalf of French Polynesia. So what those countries, either separately as one country or jointly, when their maritime zones, they are adjacent, they deposit their GPS, maps, data, anything specific to mark that what is now under their legal regime, it will stay that way, regardless if there will be some changes of the sea level rise. Because submerging of states is one thing, but another is getting those islands inhabitable. Because we cannot expect people to live on an island where they cannot grow plants or husband animals, how they could live, how could they survive? So we can see that those countries, they believe that once they secure their maritime and therefore land zones, they will always be entitled for this part of the globe, actually, because we can imagine potentially, hypothetically, that some country like Kiribati would have to move some part of its nation, for example, to New Zealand. But then they will always keep that land in the middle of Pacific Ocean to do whatever. Maybe in the future, technology will allow them to build some artificial island to be able to be habitable. Who knows? But for the time being, for the state of law as we have, this is the best solution, because those countries, they don't wait for us. Us, I mean Westerners, us, I mean European Union or NATO or UN, because it's very, very hard to achieve this agreement at international level. And I will just only mention here that from until now, there is no treaty on ocean change. There is no document how to fight ocean change or climate change. We have only one document, which is only descriptive form in 2021, how states see this phenomenon, what should be done. And it should not be surprised that those not affected by ocean change, they say, no, we don't have to change the law. The law, I mean, UNCLOS, or maybe signing a new treaty. But in contrast to that, those the most affected by climate change, they beg, they hope to get the new law protecting them. So you can also see that United Nations is stepping back, not doing enough. So those countries decided to act on the regional level to form regional law.
And I think about UNCLOS. It's only this year, actually, in November, we'll celebrate the 30th year of it being in force since 1994. And I was thinking, it is tough to get approval to change law, which is to your larger point about how we can advance customary international law to be able to bring about agreed changes. But I guess there's a little bit of effort needed there as well, right? I mean, this has to be perhaps a preponderance of states have to agree to this, to take on that practice. And of course, it has to apply to all. And that too could be somewhat laborsome, but you could say more.
Yes, definitely it can, because when we see a norm created by different type of sources of law, there would always be rights, but also duties. When we give somebody a right, somebody has to secure. So they will put on their shoulders some duties, some obligations. And countries, they don't want to do that. They don't want to, because they already have so many duties at the international level, regional level, local level, internal level. And as you mentioned at the beginning, how about climate refugees? So far, it is not codified. And here I would always ask, why is not? Well, because countries are afraid. Who or to which extent should they take care of climate refugees? Would there be some kind of international fund? Or what kind of legal rights at their own new territory, host nation territory, would be given? Would those people migrated, would there be given new identity, or would they keep their own status? Or there are so many questions of legal side, but also economic side. So countries are not willing to do so. They somehow wait what will happen, and is very slow in moving. So I would see that 21st century would be more into not creating hard law, but changing interpretation of the existing law. Why should we wait to change the interpretation? to write something to get this consensus and international level, to get signatures, to get ratification to our internal systems. It's easier, faster, more efficient when we discuss something at political level and agree on that. Because we all know what China is doing in South China Sea. We had the judgment of the Permanent Court of Arbitration. And guess what? China said, no, we will not obey this law. Unfortunately, in international law, we don't have enforcement measures. We might have some sanctions, but then again, they rely on political will. So here I will be advocating for the new world order, but also the new legal order that we will start. And again, I love the US. You guys, you master lawfare. This is another tool in hybrid warfare that our adversaries, China, Russia, are using international law against us. But we are still, holding back. While I think law can be used at both sides to protect us, but also to again to get our rights back, and especially on behalf of those the most vulnerable, like Oceania states.
No, thank you for that clarity. Let's pull the conversation and let's talk about human security at sea. Rising seas, of course, pose this existential threat that we've been speaking about, not just to the territory, but to the fundamental human security of the island populations. So let me ask you, how should international policy evolve to better address the human security challenges that are posed by this climate-induced ocean change we've been talking about?
Human security as a concept is relatively new. That was the report of the United Nations in 1994. So exactly when UNCLOS came to be binding. Before, we were, of course, focusing on national security as a state to protect a populace within our territory, but we were not touching the human factor, identity, tradition, language, and culture, everything what is so deep in us as human beings. So also NATO is touching upon human security relatively lately. I think a few years now we talk about human security in NATO. So what can be done? First, I would always say education and awareness. We have cultural awareness, but how about legal awareness? We cannot expect other nations, other regions to think like us. We still somehow do. The best example is exactly Oceania, and there is also this phenomenon of imposed law. For those countries, still post-colonial, I would say, they see law, democracy as something imposed by the colonizer. This is very hard topic, because how can we combat ocean change? How can we combat some corruption or nepotism, where China, of course, is entering in, is trying to bribe politicians, where for states, nations, this imposed law is something new, is something against them. So this is very dangerous, that we must act from the very basic level of educating population, of showing that here is, and again, your center is doing a great job in this, that there is autocracy versus democracy. What China is offering when they buy an ambulance or build primary school, it's not for the benefit of the society, tribe, clan, island, but this is to bring the values of a Chinese Communist Party. And still we don't talk about that much. And again, somebody would say, yeah, what that has to do with ocean change? And I say everything, because ocean change is just another trigger. in great power comparison, that we, the Western world, based on human rights, protection of human dignity, transparency of public administration, we must act together regardless of the threat. The threat might come from the nature, but of course, as we know, ocean change is also the effect of anthropogenic actions, but also other adversaries. And I could move on and on here. So human security at sea, I'm very happy that you are touching upon that, because again, this is not soft skill, contrary to state security. This is very core, because we talk about generations, about decades to come. So yes, a lot to do here. And I would repeat, education, education, education.
No, thank you for that. Maybe we'll pull a little bit now and talk a little bit about the cultural tides of change. I mean, the cultural identity of Pacifica people, it is deeply intertwined with the ocean, and it influences this legal and environmental strategies that they're undertaking. And so maybe you could talk a little bit more about how can international efforts to combat climate change incorporate the cultural considerations to ensure effective and respectful outcomes?
Yes, and this question is really in alignment with our previous conversation about culture and cultural awareness, because many times I hear during my lectures or courses that somebody suggests, how about we just move those people elsewhere? And that triggers me so much, because Pacifica are not parcels to be moved elsewhere. As you exactly pointed, they are people of the ocean, people of the sea. All their heritage, culture is connected with the sea. Again, those were nations in the colonial period who imposed the law, but also terminology and definitions like borders, zones, areas, countries, states. So for Pacifica, those are very artificial, not natural terms. So they prefer to work together as brotherhood, as sisterhood, to sit down and discuss. And here, the way they do is again different than ours. We, in our Western mentality, we must sign everything down. Treaty, negotiation, communique, everything in our mindset must be written, so we could prove that yes, we agreed on something. But as you know, Professor, more than me, in Pacifica, they have gentlemen's agreement. They agree on something with the hope, with this good faith, to believe that something will be done as they agreed upon. So this is very important to maybe step back, as we want to help, but how about they want to be helped, if they want to be helped, the way they want to proceed. And again, this regional practice of deposing maritime zones is just perfect example. Without European Union, without United Nations offering help to Oceania, no, this is Oceania people protecting their rights in their way, within their blue continent. So this is the way to go. And I think that could lead the way for other regions, not exactly with ocean change, but also for African countries, also for South American countries, how they tackle their own regional problems. That after this period of globalization, maybe now we come back to regionalization, that in the region, everything is simply faster, simply cheaper, more efficient. So I can see that in the 80s, we had this big increase of risk to that, because again, I can see all the pluses here and not as much we have in globalization.
No, that's insightful. Innovations in environmental governance is where I want to pull next. You know, the pioneering legal strategies of Oceania states, I mean, they could set new precedents for environmental governance worldwide. You've been talking about that. And so I want you to go further and talk about what are the most promising innovations in environmental governance emerging from Oceania, and how can they be implemented globally?
Yes, well, basically, this is what we've been discussing. That first of all, we have this new phenomenon of deposing zones. So we see this emergence of the new law, and this new law can inspire other regions. The next stage might be a treaty, might be a regional treaty, which will be binding for the parties involved, but also countries from the Pacific Rim, because they are more or less the same interested in keeping stability in the region. So I can see that this phenomenon is growing, and it will be growing. I hope in the meantime we would witness finally some changes at the United Nations level, because again we have the Big Five at Security Council, very colonial structure where our adversaries, Russian Federation and People's Republic of China, they have their veto, which is frightening, which is dangerous, which is pure evil, and I will say that out loud. So those tiny little islets and islands in Oceania, they are brave enough to change the law, to shake the law, functioning law. And as your the name of your conversation is shaping the security. So we can see that those countries, they are actually shaping and shaking the existing legal form to create something new, something beneficial, so to secure not only this generation, but generations to come.
No, that's absolutely right. I want to talk more about these voices from the margins. And so despite their significant vulnerabilities, I mean, really, the global voices of the Pacific small island developing states are really often marginalized. And so what mechanisms can be put in place to ensure that those states have a stronger voice in the international forums like the United Nations? Is there something we can really do that would strengthen their voice?
It is that the first problem is, I would call it spaghetti effect. There are so many institutions in Oceania, across Pacific Ocean, that some countries are in, some are out. This is also from the international law perspective, the most different in a sense of various legal status region. We have sovereign states, we have dependent territories, we have associated states, we have free associations, we have territories within your American law or outside of it, but still within the system. Finally, Honolulu as a state. So it is important because to which extent those entities can act freely without permission or some coordination with Big Brother. So it is also limiting them to which extent they can cooperate and create a region, to create this harmonized region. Like, for example, we have here in European Union, where the law is harmonized and every citizen of European Union has the exact same set of rights. This might not happen in Oceania because of those legal statuses. The countries, states, territories, they are not the same. So, and again, different countries, they participate and pay, because of course it's all about the money, in different international organizations. Some are regional groupings, some are IGOs, so intergovernmental organizations. Some are based on a legal treaty, some they don't have such constitution of existing. So this is very dangerous because the voice of the Oceania countries is not heard. It's not heard in Europe, in Africa, in Asia. Yes, when somebody is dealing with Oceania in the pack, then we know. But I mean, most majority of people, they would not associate this region with one organization. Like in other regions, we have this one main organization. So here is very dangerous because who can represent Oceania at United Nations level? Those countries are poor, developing, some are underdeveloped. I witnessed that myself. So who can speak on their behalf if not themselves? Of course, the US is a big friend, protector, I would say, of those islands. But again, compared to other regions who have their one voice, here is very, very difficult conversation. So I'm not sure in which direction it will go, because also due to great power competition and how China is entering the region. Yes, that's a lot to talk, and yeah, I will not even dare to begin this dialogue here, because it's just hard. I'm not saying this is impossible, but yeah, it is hard.
It's the first time I've heard the term the spaghetti effect, but I think it well encapsulates some of the challenges.
Indeed, right?
Right, it does. But I really, I think, want to give you a chance to talk a little bit more. You laid out a lot of the challenges with the role of these regional organizations. But, you know, some like PIF, the Pacific Islands Forum, I mean, they are playing crucial roles in advocating for the rights of their island nations. And so talk a little bit more. How can those regional organizations, despite the challenges you've laid out, I mean, how can they enhance their effectiveness and influence international law and security discussions?
Yes, I was actually at the summit of PIF in Suva. So I witnessed, indeed, I stayed in the same hotel actually. So I was really able to witness what was happening there. And again, from somebody from outside of the region, we might say that Oceania, Pacifica, they speak with one voice. And you know, this is not true. Like in every other region, we love or hate our neighbors. This is absolutely natural, normal. We have different access to various resources, or we don't have it. We have different historical background, different connotation with the former metropole or colony or occupiers, or this type of stuff that create legal culture. My beloved research topic, legal culture, is the set of norms is important for the society. Some societies will penalize, codify some set of norms, which is totally irrelevant for its neighbor. So Oceania countries represented, for example, in PIF, they will have different interests, different political allies, different partner nations. So this is also dangerous to create a harmonized region. Because like in the European Union, we more or less we speak with the same voice. Of course, we have different interests, the same in NATO, yet it's more structuralized. We agree on most of the terms. Why in Oceania, the game, I would say, is a very, very high stake, because we know that it's not only great power competition, it's also freedom of navigation, is access to seabed mining and all the materials laying out there, So very interesting times to come. But answering your question, the effectiveness and influence, how can those regional organizations, they enhance that? Well, I would say again, we must stop this spaghetti effect. We must have more unity, because I see that Oceania countries, they focus too much on conversation, who is with whom, against whom, under which organization or treaty, or how they perceive US in the region or China in the region. And without that unity, it's really hard to tackle ocean change. It's really hard to tackle other climate effects, like migratory species, that they no longer live in this region, but they moved totally elsewhere, and therefore population cannot longer use those this source of protein. So all of that is really dangerous and affecting life of people now, but also next generation. Not sure how to solve this spaghetti effect. So that would be long gone, and we could really sit down and then start the heavy talks.
In my last question, before we go to audience questions, I think we'll zoom out a bit and talk about adapting law to this changing world. I mean, the dynamic changes that are being brought about by climate change, I mean, they are challenging the static nature of traditional legal frameworks. I mean, you laid that out a little bit. We, wrestled with annexation and these other very long term issues that people have grappled with for centuries. Climate change is different, and we need to perhaps adapt our laws to it. So let's talk about how international law can adapt to the fluid realities of climate change, and what are the potential risks and rewards of a more flexible legal norms.
Exactly, because United Nations Convention on Law of the Sea was created far before the effects of climate change were visible. So what do we do now? Do we change UNCLOS or we do not? Do we start writing another treaty? But then should we wait, like with UNCLOS, some years, decades to get this treaty ratified? And again, we don't have, of course, US or Turkey as a member of UNCLOS. We have other countries which do not follow the norms. So what should we do? What is the best thing to do? And I would repeat that, in my opinion, the best is to change interpretation of existing international law norms, because that's the fastest way, that's the cheapest way, and it will secure stability and peace, not only in the region, but globally, because as we all know, we live in the 21st century, being the Pacific century. So whatever is happening in that region, you are actually calling from, Professor, it affects here. Also Poland, central of Europe, even though our largest struggle is war in Ukraine at our border. But still, what China is doing there and here, that's the big thing, and we must be aware of that. So flexible, yes, we must be more flexible, because law is just the effect, like a mirror for each society, what we deem necessary, what we deem sacred, saint, valuable, what we want to protect. So this is up to us, societies at local, regional, global level, to change it and how to change it. Because again, this is up to us, up to states, and how we see another state. We still work on this 1933 Montevideo Convention, which was also a regional customary law that was created by South American countries, where after the period of colonization, they didn't know who they were. Were they already independent or semi-colonies or something new? How new? From which perspective? So that showed that from the regional question, matter, criterion, they shaped a norm. And now lawyers all over the world, we learn about Montevideo Convention as a reference point. And who knows what will happen next with UNCLOS. This is just a matter of time. And I am really happy that we live in such interesting time that finally international law is being changed.
Fascinating. Well, in the interest of time, let's switch over to audience questions, and we received many. This first question is asking us about climate change and conflict. So what security challenges beyond territorial disputes could arise from climate-induced displacement, and how can these be addressed?
Climate, yes, a very good question, because it's not only ocean change, but climate change as we, for example, witness here with a migrant crisis in Europe, from North Africa, from Middle East, that unfortunately, but people, human life is being put on assault, where human traffickers are using people to destabilize Europe. Again, at the border of my country, but up north with Belarus, Putin and Lukashenko, they programmed this instrumentalized migration to use against us, the Western countries, our Western civilization. So it is already happening now. That those countries, Belarus, Russia, yes, they can use tanks, kinetic weapon, but they can also use humans. And that is the most frightening, that migrants, those people, the most vulnerable, poor, trying to change their economic status to help also to send their kids to school, all the, the basic human needs they want. It is all being used by the totalitarian regimes. And again, climate change is only another trigger to be used. So we must stop allowing that, because it's not the first year that we have this here in Europe, and it will be growing because of the problems with water and food in Africa, in Middle East, and also with the conflict where, as we all know, Hamas and Iran, they are doing far too much. But so far it's really hard to stop them, and they are also using human lives to justify their illegal tactics. A lot to cover, but yes, there is direct connotation between climate change and conflict. 21st century, where the most vulnerable are ordinary humans.
This next question pulls on what we spoke about earlier, which is about protecting climate refugees. So how can the international community ensure protection and dignified resettlement of these climate refugees, particularly those who may lose their statehood?
Yes, I would, of course, start from the legal definitions. We still don't have these because, again, migrants are not refugees. It is very often, mixed by journalists and so on. So migrants, I used to be also a migrant working all around the world, but refugee is somebody who's escaping from its own country under the threat of being killed or tortured because of his or her political, religious, and other beliefs. So here, because of climate change, we don't have that threat coming from own state. We have a threat coming from the nature. So can we call those people migrants or refugees? Who would give them rights and who will provide duties? Which country would do that? And so far, the two most important organizations, so International Organization of Migration, but also United Nations High Commissioner for Refugees, they did not introduce or invite to discussion the new definitions, which is surprising. Those two, the highest possible international law institutions, they are not issuing any debate about climate refugees or climate migrant, however you want to call them. So I don't know what has to happen, how much people, what is the number of people crossing the borders, because also we have internal people, like in Kiribati, they shift not to another state, but they move between the islands within one legal system. So a lot of legal questions nobody's willing to solve so far.
Yeah, no, we are talking about some really difficult issues today that states and international organizations and communities are grappling with, and there's no expectation that we're going to have all the answers here today, but at least we're presenting, we're putting on the table, as it were, some things to really think about. And this next one, I think maybe it pulls a little bit on our conversation earlier. You spoke about the 2016 Permanent Court of Arbitration regarding the 9-dash line, but this one is asking about South China Sea implications. So how does the South China Sea case impact the legal arguments of Pacific Island nations facing rising seas? Sure,
well,
it goes to your... Yeah, go ahead.
I wish I could be optimistic here, but I cannot, because yes, the law is at our side, but the effects of not following the law, it shows the largest weakness of international law, being exactly lack of sanctions, lack of enforcement measures, lack of funding, because in the Pacific, those two largest oceans on the planet, how can they be secured? Who would be there? Who would be responsible? How many vessels patrolling? Coast Guard, Navy, Marines, who will govern that? And yes, assuming that US would be world sheriff, would you be able to secure all of that? You might need, and the United States, of course, would you be backed up with NATO? Whereas NATO, of course, according to Washington Treaty, is only Euro-Atlantic zone, or should we focus that NATO plus? So our four partners, the Republic of Korea, Japan, Australia, and New Zealand. But then also in that case, who would be responsible? So this is very dangerous, and China is playing malicious games all over versus the Philippines, Taiwan, Hong Kong, of course, changing the law. They act very sophisticated. Like, this is what I must underline, that they don't need to use go in full scale massive confrontation, because by changing law, by interfering internal governments, by bribing politicians, and of course we all know the famous military pact, Solomon Islands and China a few years back, that also shows us how China is acting by misusing international law mechanisms, while we, the West, we still don't see law as something forceful. I always hear this from my cadets or officers when I teach, that they don't believe that the law can be a weapon. They rather see law as something cute, fluffy, pink, that like our adversaries can laugh at our values. but not be frightened by the power we get from international law. So I think it's high time to change that.
Oh, no, indeed. And I was thinking about the scope of the Pacific. I mean, a third of the planet is the Pacific area. And so it is a massive area, and many countries are so far away from it. And so let's talk about, and this next question is asking us about distinction in territorial claims. So it's a rather specific question. Does international law distinguish between natural and artificial island claims, and how might this affect Pacific nations?
Of course, it does. Everything is written in UNCLOS. And again, even though the US is not part of this treaty, it follows the law. Unlike, of course, other countries who signed UNCLOS, being Russia and China, but they do not follow. So artificial islands, it's very interesting that the island must be habitable, in a sense that person living on an island must be self-sufficient to live. And again, Chinese, they were trying to breach this norm, proving that they can build an artificial island, they can put a worker on it, and they can send him or her a dinghy with food. Absolutely not. This is against international law. This is not a definition of an island, natural island. But again, who can enforce Chinese to stop doing that or prevent them doing that? That's a conversation at the slightly different level. And I don't claim I'm an expert here, but the law can be played from two sides. And again, my big ambition, and I'm a big advocate, that we not only see how China and Russia and also Iran, Syria, Venezuela, they play with international law and internal law, but also we start to use law as the weapon to protect us, because what we are witnessing now, that those regimes are again using law against us, against own population, but we are not doing enough. So the example with island, what is an island under international law, is just a tiny little bit how law can be used and misused, or interpreted in a malicious or in a good way. And again, it's all up to us how we present the norms stemming from that law.
Oh, Joanna, this has been a wonderful hour together. I have really enjoyed this time together, and you've really enlightened us and had us think broader on what's an important issue. Let me, before I let you go, though, I always ask a guest to recommend a book for our audience, so maybe you would do so.
Thank you very much, James. And this is my biggest honor to be here with you guys. And I will recommend a book about Indo-Pacific, which is edited by me, but it's not about me. It's about my authors. There are 18 different authors. The book is called 21st Century as the Pacific Century: Culture and Security of Oceania States in Great Power Competition. Why I coined this name, and the picture, they come from my voyage, of course. It's important that authors here, they come from different countries and they represent different domains. They are military people, they are academics, they are practitioners, and they all see that to protect Pacific, we must focus on those two elements: culture and security. Security cannot be discussed without culture, but culture also must be seen in a way of security, human security and national security. So this whole conversation is embedded in Great Power Competition, which I will only remind that it's not only about money. Yes, it all started, as we all know, struggle between US and China, but I claim that it's also about the values. values we stand for, we are ready to protect. So democracy, human rights, human dignity, versus totalitarian regimes like China, Russia, who are killing, kidnapping, torturing own citizens and political opponents. And this is our legal and moral duty to say no to that, because if we will not spread our values, somebody else's values will be spread. And Pacific Islands are the most vulnerable. They are in between, literally, of our Western values countries and totalitarian regimes. So this book was published in open access. We will provide link to download this book, and I hope you will enjoy the essays written in this book.
Joanna, thank you. We will include in the program notes your book and on our webpage. So as we conclude today's dialogue, we recognize how essential sustained cooperation and innovative frameworks are in addressing the rising sea level threats facing Pacific Island nations. These conversations shape security. And I invite you to join us on October 10 for Dialogue 29, Malaysia Between Giants, with Alina Noor from the Carnegie Endowment for International Peace, who will offer expert insights into Malaysia's geopolitical strategy. Now, from all of us at DKI APCSS, thank you for joining this important conversation. I'm James Minnich, and until we meet again, aloha oi.
As always, the opinions expressed in this program do not necessarily reflect the official policy or position of DKI APCSS, the U.S. Department of Defense, or the U.S. government.